I'm doing all right. What's your name and badge number, please?
Deputy Leback.
Okay, gotcha. Are you the supervisor?
He's on his way.
Oh, okay. Is this the supervisor?
Nope, he's on his way.
I got you. Yeah, so, I mean, as you guys can see, I'm being surrounded right now. 3 patrol cars. Am I detained at this moment? Under suspicion of what crime?
Is this your
Today, we bring you a raw confrontation between Deputy Leback and a citizen who records while being surrounded by 3 patrol cars. The officer claims you're being detained, while the citizen demands, on suspicion of what crime? How far can they push you before you're forced to identify? Watch as the tension escalates and the rules get murky. If you want more real-life ID refusal and First Amendment encounters, follow the ID Refusal Pro channel. Thanks to the original uploader for sharing this footage.
Hey, how are you doing today, sir?
Good, how are you?
I'm doing all right. What's your name and badge number, please?
Deputy Leback.
Okay, gotcha. Are you the supervisor?
He's on his way.
Oh, okay. Is this the supervisor?
Nope, he's on his way.
I got you. Yeah, so, I mean, as you guys can see, I'm being surrounded right now. 3 patrol cars. Am I detained at this moment? Under suspicion of what crime?
Is this your car?
I'm not answering any questions at this point until a supervisor arrives. I will not be answering any questions. I think I provided enough as it is. So I'm being detained for what? You just said my car, but what crime are you suspecting me of committing at this point in time that you can lawfully detain me?
Okay, based on the database that I have used, you
Yep.
have a warrant out of Aurora for your arrest.
The database of what?
Okay? That's why you're being detained.
Okay.
Now, you're being cooperative with me,
Yes.
but if I feel that you're not going to be cooperative with me, I'll detain you in handcuffs.
Okay. Well, I honestly don't think there's any need for that.
Deputy Leback approaches as the filmer, a roofing employee recording his stop, calmly questions Officer Stokes about the lawful basis for demanding identification. Within seconds, 3 patrol cars surround him, signaling escalation without clear probable cause. Under the 4th Amendment, an officer must have reasonable, articulable suspicion that a specific crime has occurred to justify detainment. Simply being in a neighborhood with a company logo on one's shirt does not meet that standard. When Deputy Leback cites a database and mentions a possible warrant but cannot verify it, the detention becomes constitutionally questionable. According to Terry v. Ohio, 1968, a brief stop requires clear facts, not vague assumptions. The filmer remains polite, repeatedly asking what crime he's suspected of. The correct response in such encounters is to remain calm, clearly invoke the right to remain silent, and request a supervisor, avoiding escalation while preserving legal protection.
Even know who I am at this point in
I
time.
do. Okay? Now I'm asking
You have suspicion.
Right. Now I'm asking you for identification.
Mm-hmm.
Because I have reasonable suspicion now. This is my supervisor.
This is your supervisor. Hey, how's it going, man? How are you doing?
Good, yourself?
I am doing all right. I mean, I'm not sure what's going on here. We got a ton of police officers. I'm surrounded. I'm feeling pretty nervous right now. I'm at work, okay? I'm using this vehicle for work, and this officer, for some reason, feels that he has reasonable suspicion to be running plates around here or thinking about other stuff. I've committed no crime.
Public roadway, so yes.
Yeah, well, no, you actually have to have some sort of suspicion to actually be able to run it and go through that.
It's on a public roadway.
Yeah.
Okay.
So what is?
Identification, because that's what he's requesting.
Yeah, I know, but there has been no crime at this point, so I'm not gonna give identification.
Suspicious person walking around the neighborhood.
Is not a crime. Suspicion in itself is not a
And
crime.
he is contacting you. He
Yeah.
has reasonable suspicion to contact you.
No, that's the problem. He doesn't. What is the reason?
Reasonable suspicion
What is a reasonable suspicion, sir?
that you're walking around this neighborhood.
Yeah.
And you say you're at work, so you need to prove to us in some way that you're...
No. See, that's actually the problem. You guys have to prove that I have done something wrong. Innocent until proven guilty, right?
When the supervising officer joins, the encounter turns into a legal debate over reasonable suspicion. The filmer calmly explains that walking or working in a neighborhood is not a crime, while the supervisor insists that a suspicious person justifies a stop and an ID request. Under the 4th Amendment and Brown v. Texas, 1979, police cannot demand identification without specific, articulable facts linking the individual to a suspected offense. The filmer's argument is correct. The burden of proof lies with law enforcement, not the citizen. Labeling ordinary conduct as suspicious without a factual basis violates constitutional protections against unreasonable seizures. Deputy Leback and his supervisor overstep by equating curiosity with suspicion. The lawful response is to remain polite, refuse ID unless detained under a valid crime, and state clearly, "I do not consent to unlawful detainment." Knowledge of rights is the citizen's strongest defense against unlawful authority.
Saying right now is the fact that you guys are just telling me that I'm going to get a charge for not identifying. That's a secondary charge. For me to identify, I have to be suspected of committing a crime. I have to be suspected of committing some sort of infraction. I am not going to give that, sir, unless I am being lawfully arrested.
Okay.
Is that what's happening?
That's what's happening.
Okay. What? Can you put that
done.
down?
Can you tell me what your name and date of birth is?
Yeah, I'm being cooperative, guys.
What's your name and your date of birth, sir?
No reason to
What's your name and your
pull
date
on
of
back
birth?
like that.
Failure to identify yourself, you told me, is a crime. Okay?
Yeah, it's a secondary charge.
That's fine.
Hey guys, I'm being arrested right now.
Is there someone that can take charge of your animal?
If a call, then yes, there is.
Well, you're in my custody,
Yes, sir.
and you're not going to be allowed
Hey,
to make
call. Tell her I am
As
being
Deputy
arrested.
Leback declares that refusal to identify is a crime, the filmer asserts that identification laws apply only when a person is lawfully detained for a suspected offense. Under Hybel v. Shees 6th Judicial District Court, 2004, police may request ID only during a valid Terry stop, supported by reasonable suspicion. In this case, no evidence of a crime was articulated, only vague claims of possible warrant and suspicious behavior. Arresting a citizen without probable cause or confirmed warrant violates the Fourth Amendment's protection against unlawful seizure. The filmer remains composed, verbally compliant, but legally firm, stating he will not provide ID without a lawful arrest. The officer's escalation to handcuffing constitutes police misconduct, demonstrating misunderstanding of constitutional boundaries. The correct course of action for citizens is to stay calm, verbally assert their rights, and document the event for legal review, rather than physically resist arrest.
All right, guys, so I was arrested at that moment. I was taken to the sheriff's office and detained for roughly 4 hours. I was released thereafter with no charges. They didn't charge me with failure to ID, which they kept threatening to do. And it turns out, like I stated to them, there was no warrant for my arrest. So this is a false arrest, illegal detainment. Overall, just a bunch of nonsense from these officers.
After 4 hours in custody, the filmer reports being released without any charges or warrant confirmation, proving the arrest unlawful. Under the Fourth Amendment, citizens are protected from unreasonable seizures, and an arrest without probable cause or valid warrant constitutes a false arrest. Deputy Leback's reliance on an unverified database hit lacked legal basis. The Supreme Court in Beck v. Ohio, 1964, ruled that officers must have concrete evidence of wrongdoing at the time of arrest, not assumptions. The release without charges confirms a violation of due process and demonstrates police overreach. The filmer's calm documentation and post-incident reflection show how knowledge of constitutional rights can expose abuse of authority. In similar encounters, the correct response is to record the event, request badge numbers, and file a written complaint or legal claim instead of arguing on scene. Transforming conflict into accountability, Deputy Leback's conduct earns a grade D, reflecting poor understanding of constitutional limits and procedural law. The filmer, a roofing employee exercising his right to record and refuse unlawful ID demands, earns an A for composure and lawful restraint. The key takeaway from this ID refusal encounter is that the Fourth Amendment and rulings such as Terry v. Ohio 1968, Brown v. Texas 1979, Hybel v. 6th Judicial District Court 2004, and Beck v. Ohio 1964 collectively protect citizens from unreasonable stops and false arrests. Law enforcement cannot detain or demand identification without clear, articulable suspicion of a specific crime. The proper action for viewers is to stay calm, invoke the right to remain silent, document interactions, and later file lawful complaints if rights are violated. Subscribe to ID Refusal Pro for more educational breakdowns, and follow the original channel to support accountability and transparency in policing.